Again, I'm Courtney Radsch. I'm the director of the Center for Journalism and Liberty for those who are joining us in the room or online, bookending the conference landscape discussions after an incredible day. Thank you so much to everyone who has shared their perspectives and really deep thoughts about this. And we don't want to leave you thinking only about the problems, right? So we've heard a lot about the various challenges that monopoly and concentration and the lack of competition at all levels of the tech stack pose to free will, to democracy, to the economy, to our political life. And so now we want to talk a little bit about fixes. And we want to focus on the quick fixes because we do know that antitrust cases take a while, new legislation takes a while. So we want to get into a discussion about what can we do now or in the short term to address a variety of the challenges that we've discussed. So I'm delighted to be joined by Ben Wiseman, who is the Associate Director of the Division of Privacy and Identity Protection at the FTC, and Sarah and Max, who you met earlier today. Sarah is the Managing Director at AI Now Institute, and Max is our Director for Europe and Transatlantic Partnerships here at OMI. So let's see. At first, I just want to jump right into it. Based on everything we've heard today, if you had a magic wand and could just magically create one quick fix, what would it be? Max, let's start with you.
Can I mention two?
Okay, fine. You get two magic wands.
So I think the first is we really need to tackle these partnerships that we're seeing between the tech giants and a lot of the nominally independent players in the market. So, Microsoft, OpenAI, Anthropic and Google and so on. I think that's a situation where, regulators can still act. These companies haven't been acquired yet. So I think we need to investigate those and potentially break them up. I think the second one is we need to seriously think about using structural separation between some of the business lines of the dominant platforms. One of the things we talk about in our report is the power that dominance in cloud computing gives companies over AI because of the computing power and so on. So I think, for example, we need to seriously think about whether we need to separate their control over the cloud and turn those into separate companies. Possibly a case to do the same with foundation models, because if you own a foundation model and, for example, you own an AI application downstream, you can self-preference that application and so on. So yeah, I think those are two traditional competition solutions that I would emphasize.
Do we have the power to prevent these partnerships before they get to mergers? I mean, I think that's one of the challenges that we're seeing, right? You've got this, OpenAI that started as a nonprofit, and now it has what we've heard 49% acquisition by Microsoft. Can that be accessible to antitrust investigators?
Yeah, I mean, obviously that's jurisdiction specific, right? So each competition regulator will have their own thresholds, their own rules on what can be investigated. I mean, I'm more familiar with what's going on in Europe, so that's what I can speak to most. But certainly in the UK, for example, and in the EU, competition authorities can investigate significant investments as well. It doesn't have to be an outright takeover. Christina was mentioning earlier that the German competition authority, looked into OpenAI's deal with Microsoft, and it felt it didn't have the powers to investigate that, without necessarily saying that it didn't think there was a competition problem. So I also think, if we can't investigate and potentially block these things with our current powers, then we need to look at upgrading those powers as well.
Less of a quick fix.
Yeah.
Okay, Sarah, your magic wand, or if you're using two hands, your two quick fixes.
So we haven't talked a whole lot about instituting bright line rules, bans on the most harmful uses. I think if we were going for a quick fix, that's where I would start. So for example, emotion recognition systems are largely regarded by the scientific community to be invalid in their commercial applications. There is, if there's no underlying scientific validity, why are these in widespread commercial use? They're being used in workplaces. They're starting to get deployed widely in cars. That's, I think, ripe for a ban. Bright line rules that tackle data minimization principles, like banning the targeted advertising model, in that sort of like drives some of the worst behavior in AI. Like those kinds of measures, I think, are, you know, the place to go strongest in this current moment. And we're seeing some of those in the European Parliament's proposal for the EU AI Act. So we could, in fact, see several introductions of those kinds of bright line measures take place in the EU. We're also seeing them get passed on a community level in the US.
Yeah, whether US legislative fixes may or may not be a quick fix at this point.
City level, city, state, like working from the ground up.
Yep. Okay, excellent. And then Ben, what about you at the FTC? What do you see as some of the quick fixes here?
Yeah, of course. Let me take a step back. So I manage our privacy division, which is within the Bureau of Consumer Protection, and sort of a separate component of the agency than our competition bureau. So sort of my comments today are going to be sort of more couched on sort of the privacy side and the consumer protection side, acknowledging all the sort of concerns that have been discussed throughout the day on the competition side. So 2 quick fixes. One, I mean, I'll echo what Sarah said. I mean, comprehensive privacy legislation, it would be significant. It's what the president called for in the executive order. It's what the commission has long called for. Providing real substantive protections for all Americans across the board would go a long way to start to address some of the harms, certainly the privacy harms we're seeing in this space. You mentioned it might not be a quick fix. I think that's true. And we have been really encouraged by state laws advancing in the privacy space, 13, 14 now. Probably more at this point. So there is progress on the state side. I used to work for the Office of the Attorney General in the District of Columbia. Many of the states, like the district, have sort of mini FTC acts and are able to sort of enforce the same laws that we are at the FTC, which is also sort of encouraging. Second quick fix, more resources available for the FTC and other regulatory agencies. You know, if you look at the size of our division, we have about 45 attorneys. Our total staff is about in the 50s with investigators and paralegals and technologists. I mean, that pales in comparison when you look at some of our colleagues overseas and the staffs that they have. So, you know, really putting the resources into this type of work and empowering the FTC would go a long way.
I mean, the FTC only got, I think, 1 small paragraph in the executive order. So do you see anything that the FTC plans to do to take forward some of the issues, especially privacy? So data is one of the foundational elements of artificial intelligence, and fundamentally that is in large part an issue of privacy. Is that on the agenda?
Yeah, so you know, I think we are looking at the executive order and seeing where are ways that we can, you know, continue to use our existing authorities in ways to sort of address this issue. And you know, we have been, and in fact, for many years have done so. I mean, the FTC Act is a very broad and flexible statute. It's an old statute, but has been used repeatedly over time to address new technologies. You know, in the 30s, it was the radio, it was big tobacco. You know, mobile phones, mobile apps. And so over time, this sort of flexible and nimble statute has been used to address sort of new technologies and the harms they cause. And we're doing the same thing when it comes to AI. So if you look at, you know, classic substantiation claims, which may have developed over time in sort of the dietary supplement realm of, you know, companies not substantiating the products they're putting out, the same applies to AI. And we put out guidance on that. You know, don't say your product is an AI product if it's not. And we've brought a case against a company called Wealth Press for doing exactly that, saying it ran an algorithm to help people with their financial trades when in fact there was no AI or algorithm behind anything that they were in fact doing. Turbocharging fraud. I mean, the FTC has a long-standing history of enforcing the telemarketing sales rule and other types of frauds. When you're thinking about voice cloning and other really harmful uses like deepfakes of AI, I mean, that's an area we have a lot of experience on. You know, privacy is another one. And, you know, more broadly, you know, these are markets that we are very familiar with, that we have had enforcement authority over for many, many years. And, you know, really think that we're really positioned to take action now and have been taking action to address the issue.
So let's stick on data for a moment, because, you know, as we've heard throughout the day, it really is the underpinning of all the AI systems. So one of the, benefits for creating really robust AI is data. So I think there's this tension between, Max, you suggested, okay, well, let's, break up different aspects of the business. How do we think about data, bigness, and concentration when you get so many benefits out of big data? So on the one hand, you want better AI. On the other hand, this further entrenches the power of the companies that own the vast or have access to the vast majority of data or can, generate and surveil that. How do we address that tension in AI governance?
Sure. I mean, I think on data, we can look at the interventions that we need in kind of two areas. I think one is, if we kind of understand that data is, one of the major ways in which companies achieve dominance in AI, then by restricting their ability to leverage that data, into dominance in AI, then we can kind of rein in their market power to an extent. And I think that talks to what Ben has been talking about enforcing privacy law properly so that they're not able to just kind of hoover up people's data indiscriminately to train these models. I think, rules on kind of data minimization and so on, so that they're only using what's strictly necessary, I think are crucial. I think also, one key thing here is because these gatekeepers are active across so many business areas, they've been able to use a lot of data that they collected for other purposes and now put that into their AI model. So Google can use Gmail and search data, Meta can use data from Instagram. And I say can, but we know they're doing that already, right? So I think limiting that would be crucial in, again, kind of mitigating that advantage they have and also making it easier for others to compete. And then I think the second area we need to consider, which I think is less of a quick fix and something we need to think carefully about, but could be very powerful, is how can we open up the data that they hold and essentially sort of make it available to other actors. Laura was talking earlier about this idea of, in a way, data being a public good or public property, because it's kind of been generated collectively by all of us in using these gatekeeper platforms. And so, if there's a way that we can open up that data, I'm skeptical that would work at an individual level. People have talked about every person owning their data and then deciding when they hand it out to a company. I'm not sure that would work, but I think if there's a way to open up that data on an aggregate level, obviously we need to think a lot about privacy and how that's preserved. I think that could potentially help other actors, not just other companies, but also nonprofit actors, universities, and so on, innovate in AI in a way that's outside of those kind of monopolistic systems.
And it does.
I want to jump in on this, though, because I really think we need to contest the underlying presumption that more data leads to better AI. Because the incentive structures in the field, if you look at the past decade of AI research, look at, where people are publishing, what's happening in the leading AI conferences, the rise in dual affiliations where, professors are also working for companies, the incentive structures for AI research and development have become so dominated by the big tech companies. And this is sort of like the ground on which this current generation of AI was developed. So it's not surprising then that the literature right now is saying, well, scale equals efficiency, but that's because they're not really looking or are incentivized to look at other models of building AI. And we do have a much longer history to this field that built AI differently. And so I think the notion that scale is inherently going to lead to more innovation or more effective or more efficient AI, I think actually deserves a closer look, because I don't think it always bears out. And there are so many harms that come with the collection of the incentivization of collecting more and more data.
Well, exactly. I mean, I think if you look at the literature, I mean, you can look at the alignment literature recently, which actually shows that smaller, really high quality data sets can create better outcomes for generative AI. And that, I wanted to build on, this idea that the internet is a public good. Very interesting to think about data as a public commons, but there's also an existing law, copyright, intellectual property law, which is not being enforced. And yes, lots of that data is trained on open internet data, but coming from the journalism perspective, we know that journalism news content is overrepresented and very valuable. That's why, for example, the consumer-facing products, on search engines are integrating news into those search functions to make them more updated. That's why you have partnerships being struck with, the big news organizations and big tech to use their data. So, I mean, I definitely agree with you on that. And that's something I think we need to think about more. And I would just plug, for my quick fix would be enforce copyright, enforce intellectual property. But Sarah, in a recent report that AI Now put out that you co-authored, you said it was about computational power in AI. And you said that understanding the influence of computational infrastructure on the political economy of artificial intelligence is profoundly important. It affects who can build AI, what kind of AI gets built, and who profits along the way. So I want to move from data now to the other key component of AI, which is computational power. So what are some of the quick fixes or maybe more medium-term fixes for addressing computational power and dominance there?
I mean, in the infrastructural layer, I think these are really gnarly challenges. I mean, the quick fix is something like mandating multi-cloud interoperability. So a cloud infrastructure provider that also owns a platform ecosystem can't sort of create incentives that lock you into their ecosystem. I think that's a near-term fix, but it's only partial. And I think that the measures that are going to be most effective are the kinds of ones that Max was talking about in the form of structural separations, in the form of non-discrimination provisions, really like taking a harder look at the way that, I mean, the dominance in these infrastructures, these are like almost the tectonic plates that are shaping the way that companies behave. But I think we also need to look at them threaded with the larger platform ecosystem, with data collection practices. Like these are not, they can't be fully disentangled.
So Ben, in terms of thinking about the fact that you have kind of the power that some of these companies already have because of where they are in this ecosystem and their access and possession of data and computational power, how are you guys thinking about and how is, say, the US government thinking about this dominance? And coupled with the fact that you have, a very pervasive legal structure for a lot of these big tech platforms where they're not subject to the same liability laws that others are. They have essentially very little privacy restrictions, no anti-discrimination requirements. Like, where do you start to even get into this?
Yeah, so Chair Khan wrote an op-ed in May that sort of touches on this, and one of the themes was to learn from the mistakes that we had made with respect to sort of Web 2.0 and the policy choices that were made. If you look back, in 2000, 2001, the FTC, took back or made this recommendation not to pursue privacy legislation, and that was a policy choice, and and it took a decade until the FTC came back and asked Congress and specifically asked for specific privacy regulation. And in that 10 years, what you saw and what you continue to see in the decades since really is sort of the incentives in the commercial surveillance economy to collect as much data as possible. And so as much as it might be true that more data doesn't equal, better AI, the companies now, in the absence of really significant or strict regulation on how much they can collect, are incentivized to collect more and more. So we're seeing the same incentives that drove a lot of the harms in the sort of commercial surveillance space, driving the same types of concerns in the AI space. Now, how do we address those incentives? And that's something we've talked about at the commission a lot, is ensuring that the remedies that we seek in cases are actually addressing the incentives that are causing the harms in the first place. So if you look at some of our data security cases, we've started to impose data minimization requirements, requiring companies to have retention schedules and to abide by those retention schedules. And another place we've started to do this is in sort of deletion of algorithms and products that have been developed off of illegally or unlawfully obtained data, as we have alleged it. So, we've had some recent cases against Alexa is one in particular, where in addition to deleting data that we allege was unlawfully obtained, they also had to delete any data products that were trained on that data as well. And so that's one way in which we're looking to try to address the incentives that are leading to some of the harms that we're seeing in the space.
Yes, I did notice that idea of like, you have to, erase and get rid of the algorithms or the kind of products that you developed from that. I think that's a great development. It seems like a lot of the discussions that we have in the AI governance space are focused on the application layer of the AI, right? So the discriminatory algorithms, biased decision making. But it's much harder, I think, to talk about these infrastructural layer issues, right? The infrastructure at the cloud. So how can we help educate policymakers, and I would say also the broader community? Like, I come from a human rights background. Human rights activists very rarely talk about competition policy, and yet it seems like, this idea of self-preferencing and anti-discrimination really fits well there. So, if you were going to talk to a broader audience, hopefully many of whom are watching online, what would you advise for them to think about focusing their efforts on? How do you translate these kind of economic concepts from competition policy into the language that, say, an everyday person or advocate can understand? Max, I'm going to start with you.
Yeah, I think I would start with just making them aware of the concentration problem that we've been talking about in the supply chain today. I think, a lot of people working on AI aren't necessarily aware of it. I mean, they might be aware that, there are a handful of big tech companies that are very dominant, but they might not necessarily think about those kind of key choke points at different parts of the supply chain. So I think just raising awareness of that. And then I think linking that to the fact that, when you do have this whole downstream layer who are dependent on the models and the cloud computing platforms of a few companies, then any, vulnerabilities upstream will infect kind of everyone else operating, right? If some sort of issue with bias with the foundation model or some issue with its data is kind of magnified, then I think that kind of suggests as a policymaker you should be focusing your energies on that part of the stack rather than necessarily the kind of huge number of smaller operators downstream. I'm not saying you should kind of forget about downstream or exclude them, but I think you should focus on where the power is and the risk that then creates.
And Sarah, here in the US, we are further behind Europe in terms of, actual regulation. It's nice to have an executive order, but we know that's not as powerful as legislation or regulation. And we've seen in Europe and in the UK, they're taking this more risk-based approach versus the harms-based. And so if we're thinking, as Tim said earlier, most successful laws are those that deal with harms, not just risk. But it does seem like we have to do both. So what would you prioritize in terms of the hierarchy of harms with respect to some of these infrastructural governance issues?
I mean, I favor a different sort of metaphor for thinking through how to regulate this sector. And I think that's to look at this as a supply chain, where the obligations that you put on, the infrastructure providers are going to look different from the folks who are involved at different stages of development. I mean, certainly from an enforcement perspective, that seems like it's most logical because you're incentivizing like every actor, making sure that they have a clean house. So at least if you have to go back and then like look under the hood, have clear data documentation requirements so you know where their data is stored, like that kind of base level provision in a market that otherwise we've kind of approached in a very whack-a-mole after the fact fashion. So I think broadly, using that supply chain approach and trying as much as possible to put the burden back on companies to make sure that they're doing their due diligence to comply with existing law, and not leave it to, like under-resourced enforcers who have are doing a tremendous job given like what the task that they've been handed, and also like investigative journalists and the public to identify where these massive companies are going wrong.
I mean, just to jump in quickly, because you mentioned the AI Act in Europe, and I think that's a situation where this kind of dynamic is very much playing out. So, the AI Act was drafted and published before the whole generative AI craze and the debate around foundation models. So it doesn't reference them. That's the AI Act is now kind of in the legislative process. So there's now an effort to include them within the scope of the legislation, particularly coming from the European Parliament. But then you've had basically foundation model providers, mostly big tech and some of the companies associated with them, essentially saying, no, you shouldn't regulate foundation models because they're general purpose, and we can't predict what they're going to do. So you should focus your regulation downstream, which obviously would basically allow them to kind of do whatever they want. And it's a narrative which has actually, for example, seems to have captured the French and German governments who are now fighting against the European Parliament's attempt to regulate foundation models because they're worried about it harming European innovation. So.
But it also seems that is there a way to leverage or use the risk framework that is dominant in Europe? Because it seems like, again, like when we talk about some of the risks, it's a narrow conception of risk. I don't hear, and maybe I'm not, I didn't hear the right conversation, but I don't hear them talking about, for example, the risk to labor, to jobs. We don't hear them talking about the risk to intellectual property and the theft and the wages. The risk, it seems like it's a very narrow conception of risk. Can we use the framework to try to open up?
Yeah, I don't know if I'd call, speaking about the EU AI Act, right? I'm not sure I'd necessarily say its approach to risk is narrow. It does talk about, for example, the risks you have when you use AI to allocate work to people, for example, or in education. But I think what is missing from the Act's conception of risk is scale, right? It doesn't really talk about scale. It doesn't talk about how the larger a platform, the more that any kind of failures of that platform or biases are magnified across the supply chain. Again, that's something that the European Parliament has been trying to do with these new provisions on foundation models, but we'll see if they succeed.
And Ben, how do we reconcile different parts of the government, that might have different priorities, right? So on the one hand, there's this recognition, I think, by the FTC and other agencies about the need to address some of these, foundational competition issues. On the other hand, you've got the preferential trade agreements for tech companies, the trade agreements that are giving preferential treatment essentially to tech companies, building in Section 230 protections, building in, protections for companies that will ensure and perpetuate their dominance. Are you negotiating? Do you talk about this behind the scenes? Are y'all just doing your own thing?
So I'll address that question. I do want to go back to your question previously about how do we socialize this with the public.
Great.
And just make a plug that tomorrow there's an open commission meeting at the FTC where there are going to be 2 AI related items that are going to be discussed. One, talking about cloud infrastructure and sort of summarizing, I believe it's summarizing the results of the cloud RFI that the Office of Technology, which is a new office that has been spearheaded by the chair, put out earlier this year. That's a plug for that. Another way we can better socialize this is, the cases we bring are based on the individual facts, the unlawful conduct that we allege in a specific case, but they also speak to broader concerns. And we have, as regulators, need to do a good job of making those broader concerns clear. I think like one example we've shown in the privacy division over the past year is about our concerns about the use of sensitive health data. Julia's written on this and others, but we had a series of cases sort of where companies were unlawfully disclosing sensitive health data, as we alleged, and got bans on the use of using that sensitive health data for advertising purposes. On the question about sort of differing, incentives at the federal government level, yes, there is a deep coordination, and we might not always agree on the right approach, but there is a collaborative and a really close collaborative relationship with other agencies throughout the government. Our job at the FTC and my focus is in the privacy division is to use the tools that we have to provide the most protections for American consumers, and that is our mission. But we also recognize that there are other agencies have different missions, and we work closely with them to ensure that we are speaking and communicating.
Okay, we are talking a lot about Americans, and clearly the US government has a responsibility to Americans, but these companies, the handful that were on the slide earlier, that dominate the AI landscape, have profound impacts on populations around the world. So to what, if any extent, does that figure into how the US government needs to govern companies that are in its jurisdiction?
Yeah, I mean, so one, our orders are not necessarily limited just to American consumers. They can apply more broadly to company behavior. And again, I think the key in sort of trying to address this, and I've been at a number of conferences that have sought to do this, is to bring people together. So we're speaking in a common dialogue about these issues. And that has been sort of critical in some of the work that has gone on the international level to trying to get to some consistency about what governance could look like. It's an incredibly challenging task, especially as technology is moving incredibly rapidly. But keeping those lines of communication open and that dialogue open has been critical, at least in my view, starting what a framework could look like.
Sarah, to what extent should we and can we think about options like common carrier status, breaking up these, companies, creating new public options? How are you thinking about that? Do you think that's a fix, and where would you start?
I mean, I think they very much need to be on the table. Now, the path to getting there is, as I think other folks have said in prior panels, that's not a quick fix, but it is, the path that I think we need to be heading down. And I think one where international coordination is particularly important because, if you look just on the, question of concentration in the cloud market, I can count at least 6 different international competition and consumer protection agencies that have conducted market studies into cloud and have all converged on the same diagnosis that there is a high level of concentration in this market. They've honed in on particular practices, many of these reports as anti-competitive in the behavior of these companies, like the institution of egress fees, which is a little bit wonky, but basically what it means is super easy to put your data into the cloud, very expensive to get it out. So I think international coordination is a really important part of that front. And then building the case, with the public that there is, a massive problem with the concentrated economic power of these firms that own and run these infrastructures, building the political will to be able to push those kinds of measures forward.
Do you think that we could get international consensus that cloud services are essentially public utilities? With all this, there is this, I think, growing awareness.
Every jurisdiction has its own sort of
US.
And
let's
right.
say about
So if
US.
we're just talking, okay. So if we're just talking about the United States, there's a long precedent of these kinds of measures being implemented. So, looking back historically, that's been an approach that the US has frequently taken in the past. I think that, we have had an approach to the tech sector in the last 20, 25 years of kind of permissionless innovation, hands off, just kind of do what you will and we'll fix things after the fact. Clearly, there has been a sea change in the last, several years around social media and with the, new heads at the enforcement agencies, a new way of thinking within the White House. I think that one of the dangers in the current AI hype cycle is that it's revived some old narratives like the development of AI is inevitable. If we don't do it, someone else is going to do it. The notion that regulation is antithetical to innovation, that regulation is going to restrain or hold back innovation. And I think that it's important that we draw on what the evidence shows, and there's more than enough of it, to shoot down those narratives and continue on the path that, regulators and enforcers have been on for some time and just get the job done.
Ben, what do you think? Can we think about
legislation that would
do you think that the FTC has intervened in the past,
Yep.
right, to break up these companies that either to break them up or to impose, essentially turn them into public utilities? Because with cloud, right, it may be that bigness is what gives you the security, the power, et cetera. So you don't necessarily want a bunch of tiny clouds, but you want the non-discrimination, et cetera. Is that, you think, on the table?
So I can't speak to any sort of specifics, but what I can say, and this was actually documented very recently in a comment that the FTC submitted to the U.S. Copyright Office, sort of outlined concerns about AI broadly, but also specifically in the sort of creative generative space. But there clearly are competition concerns that the commission has with this technology, in particular, particularly as to cloud infrastructure as well. And we are looking at sort of all the tools we have in our toolkit, as we have done, I think, in a number of different areas, about how we can use sort of all the tools we have, whether it's enforcement or other tools, like our Section 6B authority, to try to address these concerns.
Great. I'm going to give Max the last word. Also, because you put out, this amazing report that really goes into the different layers in great detail, with several recommendations on both quick, medium, and longer term fixes. So last word to you, Max.
So I'll go back to the utility point. I think there is a very strong case for treating the cloud as a utility. If you think about the kind of infrastructural role it plays in supporting activity across growing share of the economy, particularly as more activity becomes digitalized, it doesn't seem that different to me, something like an internet service provider or telecoms infrastructure, or even railways. So I definitely think we should think about utility style regulation of the cloud, and that could include a number of things. I think it would definitely include non-discrimination against different customers, equal treatment, but also things like cybersecurity, privacy, and so on. What that looks like in practice, I think in the US, my sense is these kind of common carrier provisions that we've used in other industries could work. In Europe, Andreas Schwab earlier was talking about the Digital Markets Act, which in some ways you could say is a type of utility regulation, because it designates a small number of big tech platforms as gatekeepers, and it says they have special responsibilities. So it was a big mistake, actually, that in its initial designation decisions, the commission didn't include cloud in there. We and others are pushing for that to happen. So I think that's one route. And then I think also, we should potentially consider in the future, depending on where things go with foundation models, if they do become increasingly infrastructural, and if they are used across loads of different sectors, again, I think we should consider giving them kind of special responsibilities, given that role.
I would add also, I think, I don't know if it could be a quick fix, because it's something we can all do today, is the narrative. We have to change the narrative. We have, I think today, really demystified AI, right? What is AI? What are the component parts? And introducing the idea of oligopoly and monopoly and the dangers that these concentrations of power pose in all sorts of ways, the harms that they cause, the risks. I think that's a quick fix, that if we all start talking about this in our domains and we give these tools to the people that we work with, that might be part of the fix, because people start talking about it in a way that will suggest certain changes. So with that, I want to thank our panelists. I want to especially thank Sarah and Max and our host institutes, and turn it back over to Barry to conclude the day. Thank you.
So we've just saw how easy it is going to be to fix this all. Been here for a long time, so I'll just cut right to it, and then I'm going to turn it over to Amba for the final word. I want to thank this amazing events team at Open Markets Institute. This is, Kat, Ashley, Kanzada, Karina, Esmeralda, Austin, Max, Audrey, Daniel, Anita. The whole team, has put on 4 very large events in the course of 9 months, and 2 in the last 7 weeks. And this one, as I mentioned before, put the whole thing together in 7 weeks. And that's because, when there's a fire, you got to go out and put the fire out. So we couldn't wait. And it's just, anyway, thanks to everybody who put this on. I just want to thank also our fantastic partners, Sarah West, and Emma Cack. And please, I mean, these guys are the stars of not just of the future, but today. And I want to thank all the speakers. Just want to note, I mean, Christy Hoffman and Christina, they really went out of their way to get here from Europe. I mean, they had extremely tight schedules. It was not easy. I mean, a number of folks who came from the West Coast, from New York, it was the same thing. Thank you all. But, Christy and Christina, they were suffering on those transatlantic flights. I want to also quick thanks to some of the allies who have actually helped to chart this course forward. Public Citizen has done some really great work. Economic Security Project. We have right here Becky Chow, our friend and our ally. Just want to mention the work of Tejas Narachania and Ganesh Sitaraman, who've done they put out a really important paper about a month ago. This is very much a group effort. And then last, I just want to thank all of the folks at the FTC and the DOJ and the White House, in the European Parliament and in the European Commission, enforcers in South Africa and in Brazil and in Australia. This is a worldwide fight, and we have heroes who are walking the earth today carrying really big, broad axes, and they ain't afraid to use them. So anybody who has been panicking about AI, stop it. We got it under control. There are adults in the room and they are armed to the teeth. So now, Amber.
Okay, I'll follow up maybe with some closing thoughts. And I feel like we're at this kind of tricky inflection point in AI policy. It has all the makings of opportunity, of a very tremendous opportunity, but we're also seeing, core public language or public interest language be co-opted by private interests, and this is what makes it so tricky. So everyone is suddenly pro-regulation, pro-audits, pro-privacy, but the one term that I think is still and will not be co-opted is concentration of power. And I think that's an argument that we, as kind of public interest advocates, are bringing to the table and is often going kind of unchallenged, because there is no challenge that either incumbent big tech companies can bring to that argument, nor for the many so-called startups that we like to call barnacles on the hull of big tech, right? So I feel like that we need to bring that concentration of power analysis. We need to thread it across policy domains outside of competition. It is what will make sure that algorithmic auditing is not captured and is actually a meaningful policy response. It will help prioritize policy and make sure that our bright line rules are kind of prioritized towards domains like worker surveillance, which are ways in which AI is being used to erode worker autonomy. So I think that power analysis is crucial. And Sarah and I would really just like to thank the Open Markets Institute, and particularly Barry, for bringing this room together and bringing this conversation together that does kind of bring these different worlds and these different silos together, put them in conversation, and also demonstrate the power of that analysis really threading through our policy demands. So thank you so much, and thank you to the OMI team for doing all of the heavy lifting with organization. And we hope this is a sort of event is instructive to the field more generally.